So if your co-parent stops paying child support, unfortunately, you cannot withhold your children for parenting time. Those two issues are not related and they are not dependent on each other. At the end of the day, it's what's best for the kids, and while not paying support is not what's in their best interest, cutting off contact with that parent is far worse. The way a court determines which parent gets primary custody of the kids is through a method called a best interest analysis. The court's going to review a number of statutory factors. They're going to look at both parents, look at their fitness, their ability to get along, and then make a decision as to which parent is in fact in the child's best interest to have primary custody. They'll look at the proximity of the parties to each other. They'll look at the parties' ability to cooperate, get along, and agree. They'll look at the history of domestic violence and a number of other issues to make a determination as to which parent is better suited to be the primary custodial parent. So if your child's saying that they don't want to go for parenting time, unfortunately, the answer is not super clear cut. The reality is there's a court order in effect, and if you don't comply with it, you could be held accountable by a judge for not adhering to the order. However, you start looking at the child in question, and if we're dealing with a 6-foot tall, 200-pound 17-year-old, the reality is you're not going to be able to pick them up and put them in the car. So if this starts to happen, it's worth your while to do some investigation, talk to your child, see what the problem is, and see if you can work the issue out. Otherwise, if you're not making the child go, the other parent is going to have a right to file an application with the court to try to compel that parenting time take place. So custody can be changed at any time. The standard in New Jersey is change in circumstances. So what facts and circumstances are different now than what existed at the time the original order was entered? And is that change warranting a review of the parenting time agreement that's in the child's best interest? So an example of that could be, did the parties move further apart or closer together? Did somebody marry a new spouse that's creating problems with the child? Somebody get a new job that's keeping them out of the house a significant amount of time? There's as many reasons to look at modification as there are stars in the sky, it seems, some days. And as long as you can demonstrate for a judge that change is significant and in the child's best interest, you can apply to have your parenting time changed. If you have any questions about child custody, give us a call at Smedley Law Group. We will be happy to sit down with you for an initial office consultation and talk about how best to allay your concerns.